have some questions at the end. I had some of the questions on the screen behind Josh but he was answering as we were going. But we're going to move to Craig Ackerman now, and yeah, you got it. I was going to run back there, so Craig.
Thank you very much, Desiree. And again, it's a pleasure to be here. I'm going to do my presentation with my good friend Ashish Desai, who's also a lawyer out in California. We represent truck drivers in all kinds of cases involving unpaid wages, trucking school fraud, all sorts of things, misclassification. We're going to kind of go back and forth. And since time's of the essence, I thought I'd start with a lawyer joke about time. So this lawyer passes away at very young, unfortunately, goes to heaven. First thing he says is to the Almighty, wants to make an objection. So the Almighty says, well, what's your objection? He says, I was so young. He says, not according to your timesheets. So, yeah, time is of the essence. The other good one is, a lawyer, a doctor, and engineer were debating what's the oldest profession. The engineer said on day 3, God took the chaos, he made order, that's old. The doctor said on day 6, God did surgery, Adam and Eve. And then the lawyer says, well, who do you think made the chaos at the very beginning? So Ashish and I are going to try to unravel some of the chaos. It used to be a statement. The interesting thing is we're both kind of from Texas. We both went to law school here in Texas. I grew up here in Texas.
Well, I was going to say the interesting thing is that we both grew up in Texas. We both went to law school in Texas, all right? I went to University of Houston. He went to Texas, which is where I went to undergrad. And we both moved to California to practice law. That tells you a little something about the employment laws here in California.
And then somehow he got my tailor and he copied my outfit for today after all that. So I wanted to start out with an interesting topic. How many truck drivers here are either over the road or line haul or paid by the mile? Okay, so we got a fair percentage, maybe about a third. How many are local drivers who are hourly? Not too many. 1 or 2. Okay. So,
and are you based in Texas or somewhere else?
Hawaii.
Everyone in Texas, though, right?
Yeah. So, there used to be an expression, as California goes, so goes the nation. I don't know if that's true anymore, but we've noticed a lot of things the last couple of years. I want to talk about the important topic of detention time, rest breaks, non-productive time, waiting time. For truckers who are paid by the load or by the mile or on any kind of piece rate, this is an issue that comes up all the time. And I want to recognize Alan and Donna Smith, who've been fighting for this issue on behalf of truckers for probably more than 20 years, trying to recognize the fact that truck drivers should be paid for all time worked. And this is a principle that obviously Ashish and I hold very dear. What's interesting is, if you think about it, under the US law, federal law, something called wage averaging is allowed, where you take the amount of time you worked over the whole week, you divide the amount of wages you got, and as long as you earn $7.25 an hour, that's legal. But not every state looks at the minimum wage that way, and including California. A lot of states look at it, you gotta look at it each hour. Did you get paid minimum wage for each hour? And you're not allowed to average out the pay that you get for certain things to cover other things. So if someone tells you they're gonna pay you 35 cents a mile, you're getting paid for when the tires are turning for that specific task, and that doesn't cover the time you're waiting at IKEA or whatever it is, the 3-4 hours of detention time. Now, to be fair, a lot of the industry does have policies that after a certain amount of time, maybe 2 hours or whatever, they'll start paying detention. Some companies don't have that, and even for those that do, why is it that the truckers have to basically eat the first couple hours at a time when they're waiting around at the dock? So it was actually Ashish's case back in, I think, 2012, 2013, against a company called McLean Trucking, that in California, a federal court in California ruled for the first time, actually I think it was 2011, Ashish, now that I think about it, that non-productive time for truckers has to be paid separately and hourly, and wage averaging isn't allowed in California. So that really opened up a whole new way of looking at things, which is kind of, I think, revolutionary, kind of groundbreaking for the industry. A lot of carriers don't like it, don't understand it, are still trying to fight it,
Greg, let me just interject real quick. One of the things that we're doing now is that although we created this great law in California, and it probably applies in a couple of other places, maybe New York I can think of, and some other states, but one of the interesting things is, even if you're a Texas-based driver, Let's say you travel all the way to California. Let's assume you have a layover in California and you spend more than 1 day there. And then you come back to the great state of Texas. Well, spending that 1 day in California now is going to provide us with a basis of saying to the employer that during the time that you're in California and working, the California law now is that if you have people come into California and take advantage of our sunny state and deliver goods here, then you have to comply with the California wage laws if your drivers are there for at least 1 day. So another area to think about, and we're both thinking about this when we're going out of the box to try to make sure that you guys are paid for everything that you can get paid for, that's one of the interesting things that maybe everybody here should think about.
Yeah, that's very true. And since that case Ashish did back in 2011, the California legislature and the courts went ahead and codified that as the official law of the state. So now, any driver in California, whether they're a resident or whether they come in and work for a day or more, they have to be paid separately and hourly for all of their on-duty, not driving time, which would include waiting, loading, and unloading. It would include rest breaks in California. It would also include fueling time, paperwork, or EDL time. All that stuff has to be paid separately and hourly. That's a movement that's pretty revolutionary. It's no longer just limited to California. The state of Washington has now adopted similar principles for rest breaks, and the Washington Supreme Court's going to be ruling in the next couple of months on whether the non-productive time also has to be paid separately and hourly. But the thing is that as these cases are brought, companies are having to face up to the possibility of actually changing their policies across the board. Not just for one state, but maybe regionally, if they're a regional carrier. Because obviously if they've got some drivers in California who are getting paid for certain things, the other drivers are going to say, well, hey, why don't I get paid? When I'm in Henderson, Nevada, doing a pickup there, I got stuck there for 3 hours. Why don't I get paid for that? So it's really kind of, Ashish, I don't know if you've noticed, have you noticed any companies changing their policies, on an across-the-board basis, or is that something they're concerned about in any of the cases that you've brought or been involved in?
You know, in the 7 years I've been involved in the trucking industry, and you guys, some of you have been involved in a lot longer than I have, I've noticed one thing for sure. These companies don't do a thing unless they have to. And the only way I have noticed these trucking companies changing, even when you have them dead to rights, even when you have their hand in the cookie jar, we got a great violation, they'll still say no. It will still take 2, 3, 4 years of usually litigation. And the only way they change is if they're in it, they're going to get hit for something worse, then they make a calculation to say, well, looks like we're about to get hit for something worse, we might as well pay, these claims. But it's not until you take them all the way down there.
Yeah, unfortunately that's been our experience as well. The industry for many years tried to argue that they don't have to comply with the state and local laws. They only have to comply with DOT and the federal laws, and that the federal laws should preempt, which means basically to nullify all the state and local laws. And at one level, you could kind of understand it, the simplicity, particularly if you got an interstate company operating in a number of states. They were concerned that this raises a level of complexity. But those arguments all lost in the courts. And there was a major case a couple of years ago, Dilts versus Penske, went up to the Ninth Circuit Court of Appeals, and the court said, no, if you're operating in a certain state, the meal and rest break or these separately paid for non-driving time obligations, those are not preempted by federal law. The United States Supreme Court refused to hear that case, so that became the law of the land for the entire West Coast. Recently, J.B. Hunt tried to get the U.S. Supreme Court to rehear that same issue again, and the court said no. And that's the only federal appellate court, one below the U.S. Supreme Court, that's ever addressed that issue. So
Craig, of course, then the trucking industry gave up, of course, right? They went all the way to the Supreme Court. The Supreme Court said no twice. They lost in the Ninth Circuit. They lost in every district court imaginable. Surely they gave up then, right?
Well, if you can't win in one forum, you got to try a different forum. And that brings us to what's happening now on the legislative front, which is for the last 5 consecutive years, Representative Denham, who's from Modesto, California, who's been getting quite a lot of money from the trucking industry according to the public filings, has been trying to add on to pretty much every single funding bill that has anything to do with trucking. Transportation, Housing, Urban Development, Federal Aviation Authorization Act, the Highway Act of 2015, the Omnibus Bill last year, the Omnibus Bill this year. There's always something called the Denham Amendment. And the Denham Amendment basically says, you know, it's a law that says no trucking company involved in interstate commerce has to comply with any state or local law that will require them to pay more than they have to pay under federal law, which is $7.25 an hour. Well, if that amendment ever gets passed, and by the way, it has now passed the House of Representatives for the second time as House HR number 4, and it's the Federal Aviation Authorization Act. You know, Congress has until September 1st to fund the whole government. Usually they kick the can down the road with these continuing resolutions. It takes them until like March to do it. They should have Mrs. Nobles, my 4th grade teacher there. She was really good at balancing checkbooks and making sure you could keep deadlines. But anyway, so they're probably not going to do it on time. But this HR 4 is now on the Senate side. If the Senate passes it, it'll probably become law, and that will forever ossify or solidify the industry's right not to pay separately and hourly for any of this stuff. So we're hoping that doesn't get passed. Alan and Donna, Desiree have done a lot of social media campaigns to try to raise awareness of this issue amongst truck drivers. And of course, the ATA and the carriers are very much against this, and they put out a lot of information saying, you know, this is going to force drivers to take breaks, and there's a lot of disinformation. I'm actually going to be debating, I think, the head of the ATA on this issue on Road Dog Radio in a couple of weeks coming up. Nobody's going to be forced to take anything in Washington State, whether you take a rest break or you don't. You still have to be paid separately and hourly for the extra 10 minutes every 4 hours. In California, the company has to make the break available. If somebody wants to waive it, you know, they're allowed to do that. All that stuff is being put out there because, in my opinion, the industry would like to maintain the current flexibility that they have to pay as little as possible and to have the drivers eat their non-productive time, etc., because that foists a huge amount of cost, you know, onto the drivers. And they don't want to be forced to have to, by any state, let alone California or Washington, or, you know, my Republican employment law teacher at NYU when I was there, Sam Estreicher, used to call it the People's Republic of California. But anyway, no carrier wants to be forced to change their policies by a state law, particularly on the left coast. But, you know, not everything that comes out of California is bad. I mean, right? There's some good stuff that comes out of California occasionally. The beaches are nice, we got sunshine, Silicon Valley, and, you know, there's a lot of great stuff in Texas too. This happens to be a good one because, as Alan and Don and other people have put out there, there's 15, 20 hours a week that a lot of truckers are working without getting paid, right, Ashish?
You know, when you take a look at this, all we're trying to do is make sure truckers get a fair wage. You guys are already doing the work. There's no question about it. When we come in there and ask for money, we're not asking for a windfall. We're asking for the 15 minutes of pre-shift time and 15 minutes of post-shift time, even though it might take a little longer. That's not unheard of. Currently there would be no compensation for that in any company.
You're talking about inspections?
Inspections, the pre-shift inspections that everybody has to do. In Texas, you wouldn't get a penny for that. Why? Because it would just be part of your compensation. It's well, here's your compensation. It's based on driving. It's based on 33 cents a mile, 27 cents a mile, 43 cents a mile. Well, I ask you, if your wheels are not rolling, how are you earning any compensation? Your wheels have to be rolling for you to make your 43 cents. So, when you're doing your pre-shift inspection, your post-shift inspection, waiting for a customer, doing all the other stuff that you guys are doing, the wheels are not rolling. You're getting paid 45 cents per hour, but guess what? No one's going anywhere fast. You're sitting still. So those are the kind of arguments we make, and we win consistently in different places. And that's the kind of stuff that we're trying to get, and this Denham Amendment stuff is going to wipe that out.
Thank you very much for listening to us on these cutting-edge issues of detention time and rest break pay. We're going to hand it back to Desiree now.
Okay, thanks very much. All right, we got next up Paul Taylor. A lot of you know Paul.
Is this working? No? Oh, there it works. I don't like being back behind tables. I don't know why. Sorry, guys who are filming here. So, just a little bit of background on me. I grew up in the trucking business. My family has been in the trucking industry since 1935 or 1936, when Grandpa was the terminal manager for a trucking company in Fargo, North Dakota. And they continue to be involved, although less in trucking now, more in brokerage. So I have been representing truck drivers for 34 years, my entire career as an attorney. The first 10 years, though, I also represented trucking companies. So here's really what I do. I represent drivers nationally in 3 areas. First is wrongful termination. Those are cases under a law called the Surface Transportation Assistance Act. 2, I represent owner-operators on cases involving lease disputes. Say, for example, you're paid on a percentage and you think you might be getting skimmed from, and you probably are. And 3rd is I represent drivers on DAC report issues. And then there's a smattering of things I do with respect to drug and alcohol testing. The people who profess they never used marijuana and tested positive and can't possibly understand how that happened. You know, not a lot to do for them, but there are sometimes situations where we can do things. So I'm just going to give you a quick whirlwind tour of the Surface Transportation Assistance Act. Passed in 1982, signed into law by Ronald Reagan. It's a law that gave us 48-foot trailers and 80,000-pound roads on the national network, but it had a little provision in it called the Employee Protection Provision. And for purposes of the statute, an employee includes an owner-operator. And that law says no person may retaliate against a driver because that driver either A, makes complaints to the employer or the government about violations of commercial vehicle safety regulations, or 2, refuses to drive because driving would result in an actual violation of a commercial vehicle safety regulation, 3, refuses to drive based on a reasonable safety concern, and 4, gets retaliation is prohibited against a driver because the driver accurately records on-duty hours. Now that's not the exact way I would have liked the statute to be written when President Bush added extra protections in 07 to include the logbook falsification protection against retaliation for false logbooks. So that's my bread and butter. And those cases go through the Department of Labor. The Department of Labor is much more friendly. Their judges are much more friendly to whistleblowers than are the federal courts in normal employment suits like sexual harassment, sexual discrimination, Title VII, age, things like that. We have a very easy standard to meet in those cases, which I'll get into briefly or shortly. So just to give you some examples of protected activities. Writing up a vehicle inspection, writing something up day after day because it's not getting fixed. If it's something that relates to a violation or potential violation of a commercial vehicle safety regulation, you're protected. Telling the boss, your equipment is junk, I got an audible air leak, a leaking hub seal, 4 ball tires, and I'm sick of running your crap. That's a protected safety complaint as long as it's made to a supervisor, any supervisor. Threatening to call the DOT on your employer because they got junk equipment, whatever it is. A case called Theron Carter versus Martin Transport. I know they're out there somewhere. I saw their booth. Maybe they're in here. That's a case that stands for the proposition threatening to call DOT is a protected safety complaint. So those are just examples. In other words, to have protection for making protected safety complaints, you have to have a reasonable belief, an objectively reasonable belief that there is an actual or potential violation. You don't have to prove one actually exists. Another example of protected activity I told you about, refusing to drive because driving would violate a commercial vehicle safety regulation. Now, that statute doesn't say it has to be an out-of-service violation. It says any violation. So if you're 100 pounds over the legal limit and you can't slide your axles enough to bring it into compliance, you're protected against retaliation for refusing to drive because I don't care if you're 10 pounds, 5 pounds, 100 pounds. We won a case, came down about 4 months ago called Palter versus Central Cal Transportation. She was 650 pounds over on her axles. She was set all the way back in California, couldn't slide them enough to get it legal, and the dispatcher said, you can legal 35.5, which is a lie, and he said, slam the trailer. In other words, get it cranked up and slam on the brakes and try to shift a load of tires off the trailer tandems. We won that case. The judge said, well, he was attempting to coerce her to drive actually over. You're not going to move, and he believed that she couldn't move 600 pounds to get the load legal. So that's an example. There's other examples of protected activity. Refusing to drive because the weather is so hazardous that driving is unsafe, or so likely to become unsafe. You all know the rule, no driver shall drive, when conditions are sufficiently dangerous, operation shall be terminated. 392.14, I believe, is the regulation. We had a driver, Cynthia Ferguson. I'll name some more names. Ferguson versus Prime. Well, actually, the legal name is New Prime. She was told you could have been halfway around the country by now, chain up and go. She was at Sparks at the bottom of Donner and refused to go through during a bad snowstorm. So these are the types of protections you can get. We have habitual violators who we've sued multiple times. Had a case, Brian Ford versus Prime. He was on medication, narcotic medication, and they blacklisted him on DAC because he would not return the truck he had under lease, and they put an abandonment on DAC when he refused to return the truck because he was on narcotic pain medication. So those are some of more of the minor things. But if you had other major things, if you had a tail light out or one of the 3 clustered marker lights out and you refuse to drive, you're protected. Well, not a lot of trucking companies want you driving there if you're not going to drive without, with one marker light out. But that is the law in those cases. So a little bit about what you can get as a remedy. So if you go through the process, if you win, and this is always if you win, you can get reinstated. That's the nice thing about most employment laws is if you're illegally fired, you're entitled to reinstatement. 2, you can get your DAC report cleaned up. Whatever retaliatory information is on there, and abandonments we all know are killers. You might as well have a positive drug test on your DAC report as have an abandonment because you're not going to get hired. So you get your DAC report cleaned up. 3, you can get your back pay provided you've made sufficient efforts to look for work. That's called mitigation of damages. Next, you can get compensatory damages for mental pain and emotional distress. Getting fired is traumatic. Getting fired for doing the right thing and wanting to be a safe driver is humiliating. So, these are things. We had a case against R&L Transfer where a guy lost his home. He refused to go out in bad weather. Really bad weather. And I know there's some people say be a super trucker and man up and go ahead and go. I don't subscribe to that theory. If you're going to refuse to drive due to bad weather, you should be legally protected. So you can get back pay, compensatory damages for mental pain. The statute allows punitive damages up to $250,000. And the best thing is that if you win, you can recover attorney's fees. So that allows us to take those smaller cases. I will tell you what, one of my very early cases under this statute was a case where it was called Esch versus Roadway Express. He wouldn't go out in bad weather. He was suspended for a week. He was out $900, and darn, the company wasn't going to give him his $900. We tried it twice because it had a remand. We went to the U.S. Circuit Court of Appeals after an internal appeal at the Department of Labor. Went to the U.S. Circuit Court of Appeals, and Mr. Esch got his $900, and the company wrote us a check for $70,000. And that's back when my rate was a lot cheaper. But that allows us. A lot of people get upset about attorney's fees. Sometimes, who should get attorney's fees? They should be working for 1/3. Well, nobody's going to work for $900 of 1/3 of $900. But the fact is that these lawyers here in the statutes we go under, we're allowed to take those really risky cases because of statute, because there's things that are in the public interest. Just a couple quick things. To protect yourself under this whistleblower statute, how am I doing for time, guys? Am I okay? Yeah, okay. You're good with me talking. Oh, okay, to protect yourself under these cases, the best cases I get, one of these guys said it earlier, is when we're contacted before somebody's really fired yet, okay? I get drivers, they'll call me at 11 o'clock at night. My website lists my cell phone, and people can often reach me at night. Hey, Mr. Taylor, I've got this truck. It's got an audible air leaking hub seal, 4-ball tires, and I'm afraid I'm going to get killed. What do I do? And we can tell them, this is what you should send on the Qualcomm or BeepleNet message. Please send tow. This truck is unsafe. Here's what's wrong. And you take pictures. This day and age with the technology that you all get, there's no reason you can't protect yourself against claims of retaliation. You know, put good, clear stuff on the Qualcomm messages, take pictures. You can, there's a tabacall.com, and in all but about 12 states are single party states where you can record and build that case and have that evidence. So, you know, just in case you need it, because one person's word against another is sometimes really difficult. And preserve those records, bills of lading, logs, toll tickets, things like that that can establish where you are at certain times. You know, that evidence is important. And one more bit of advice before I move on very briefly to skimming. Stay off of Facebook. You know, I will tell you, start yakking about your case on Facebook is not good. I had a driver who said he was emotionally traumatized and financially destitute because of an illegal firing, and the other lawyer at deposition whipped out a Facebook page from my client saying he had just bought a race car. So this financially destitute driver just bought a race car, and I said, don't you think it would have been important to tell me about that race car you bought? So, you know, maintain good relations with your attorney. Quickly about skimming. If you're paid on a percentage, you are not entitled to receive a copy of the load confirmation sheet. You are entitled to see, upon reasonable notice, a copy of the load confirmation sheets used to calculate your rates. But you're not entitled to get copies. Okay? A couple other areas where skimming occurs are markups on insurance. If you're buying your bobtail or physical damage through the company, you know, they'll mark it up. They're not entitled to unless it says so in the lease. Basics of the leasing regulations, which we sue out those cases in federal court. There's a right of action to sue them. Carrier cannot charge you back unless it's in the lease, and they have to charge you at cost unless the lease sets a specific amount. And third, anything that you're getting charged back, whether it's damage claim or even a $1.25 com data check charge, it has to be allowed for by the lease, and you're entitled to receive written proof of those charges. So that's it in a nutshell. I bet I went over my time.
Thank you, everyone. Are we going to take some questions, Desiree?